So I hope everybody is aware of the rules and regulations. But still, I'm repeating again that whenever you will try to answer that particular question, first you need to mention the question number along with your answers. So also today is very interesting topic. So let's get started. As a quiz organizer, we have with us Arpana Sachdeva. She is academician and associate at 𝘓𝘓𝘊𝘅. So I welcome you, Arpana, and without any further delay, let's get started.
Thank you, Anu. So let us start with our quiz on law of contracts. So there are 30 questions, and you will get 45 seconds for each question. Okay, so let us begin with our webinar. I'll just share my screen. Is my screen visible, Anu?
Yes.
Yes. Okay.
Yes, we have 30 questions in total, and time allotment, Arpana ma'am will tell us.
40,
And I'll keep the time.
45 seconds.
45 seconds. Okay.
Okay, so let us begin. Our first question over here. The first question we have is Carrill clause means disputes arising out of contracts shall be referred to municipal court of state which grant concession. Dispute shall be referred to international tribunal only. Dispute can be referred to the state which grant concession or the state to which the foreign concessions belong. Dispute cannot be referred to court, but shall be sorted out by way of negotiation.
And your time starts now. Ten more seconds to go. And time's up.
Yeah. So the correct option is option 1. That is, disputes arising out of contract shall be referred to municipal court of the state which grants concession. So here I have also given the explanation to the question. So you can just take the screenshot of the questions if for your future references. Now the next question we have is B accept the proposal of A by posting a letter of acceptance to A. This acceptance cannot be revoked by B as he can already accept the offer and posted the letter. Second option can be revoked by B before the letter reaches A, can be revoked by B as soon as the letter reaches A, and the last option is can be revoked by B at any time after the letter reaches A.
And your time starts now. Ten more seconds to go. And time.
So the correct option over here is option 2, that is can be revoked by B before the letter reaches A as per section 5 of Indian Contract. Next question we have is the rule initiated under the section 65 of Indian Contract Act 1872 is applicable when a contract is void by mistake, uh, failure of consideration, impossibility of performance of contract, and last is under all the above circumstances.
Your time starts now. Fifteen more seconds to go. And time's up. Please stop answering.
The correct option is option 3, that is failure of consideration. Now, next question we have is, which provision of Indian Contract Act embodies the rule and initiated in Kelton's case relating to appropriation of payment? Section 58, 59, 60 or 61?
Time starts now. Ten more seconds to go. Time's up.
The correct option is option 2, that is section 59. Now let us move to the question number 5. It says, while determining damages, which of the following is taken into account? Inconvenience caused by non-performance, motive of breach, manner of breach, or all of the above?
Your time starts now. Participants, please try to participate, though we are getting answers from our audience. Ten more seconds to go. And time's up.
Thank you, Anu. The correct option is option 1, that is inconvenience caused by non-performance. Now, question number 6. Amar enters into a contract with Suresh, from which Suresh is guilty of fraud. Amar can recover damage for actual loss suffered, set aside the contract and recover damages, set aside the contract but cannot revoke damages but cannot set aside the contract.
The time has started, participants. Please mention your question number. Fifteen more seconds to go. And
Yeah. Thank you, Anu. The correct option over here is option 2, that is set aside the contract and revoke damages. Now, Let us come to question number 7, which says, if a contract consideration could be supplied by only the promisee, even the promiser, only by parties to contract, even stranger to contract.
Your time has started. Five more seconds to go. And time's up.
Thank you, Anu. The correct option is option 4, that is, even stranger to contract can supply consideration. Now, question number 8. Under the Indian Contract Act, a minors agreement has the same consequences as a drunkard's agreement, a fraudulent agreement, monk's agreement, or mistaken agreement.
Time started. And more seconds, participants. And time's up. Please stop answering.
So the correct option over here is option number 1. That is a drunkard's agreement. Question number 9. The leading case of Carlill versus Carbolic Smoke Ball Company is related to general offer, counter offer, invitation to offer, or lapse of offer.
The time has already started. Ten more seconds. And time.
Correct option over here is option 1, that is general offer. Question number 10. The remedies for breach of contract are punitive damages, nominal damages, compensatory damages, or explicitory damages.
Your time starts. Ten more seconds. And time's up.
So the correct option over here is option number 3, that is compensatory damages. Question number 11. Specific performance as a remedy for breach of contract exists in section 73, section 74, section 10, or specific relief act.
And your time starts. Five more seconds. And time's up.
Thank you, Anu. So the correct option over here is option number 4. Now, question number 12, the doctrine of privity of contract means that a contract is a private affair between the parties. Consideration can be supplied only by the parties to contract. The contract can be enforced only by civil or private action. Only parties to contract can sue and be sued upon the contract.
Am I audible?
Yes, Anu, you are audible.
Yes. So I was just asking what was the correct answer for question number 11?
Question number 11, option number 4.
Okay. Okay, one thing more, I was asking, like, participants are asking for little explanation, if you can give.
Yeah, sure. We can.
Okay, so I lost the track, I guess. So I'm giving 15 more seconds, everybody. And time.
Thank you, Anu. That is correct option is option number 4. That doctrine of privity is a doctrine of contract law where it says that the contracts are only binding on the parties to a contract, and that there no third party can impose the contract or sue under it. Now, question number 13 is quid pro quo means
Yes.
something in return. Yes, Anu?
Yes. So I was just asking for like 5 minutes break, everybody, and we just quickly try to tell you again that we at 𝘧𝘊𝘂 is coming up with our new workshop on judiciary, and it's an exclusive one. So I'll request each one of you to kindly see that workshop, and I'm just quickly sharing with you all the important timelines for the same, since many of our participants are regular participants, so they are aware, but still I can see there are some new participants to our session today. So I'll just quickly tell you that we are preparing judiciary preparation workshop. Is my screen visible?
Yes, Anu, your screen is visible.
Okay, so participants, I'll just after this 5 minutes, I'll share with you one link where you will see this sort of page in front of you all. Here you can see that we are going to do a workshop, and before you start your preparation, you might have certain questions regarding judiciary preparation and how to sustain your preparation. So I believe that this workshop will try to cover all the questions. Okay, so we'll see that there are certain things which you need to keep in mind, that this workshop is going to be held on 40th December. Just remember this date, 14th December, the date of this workshop is, and the timing would be 6 p.m. to 9 p.m. And there is a one requisite of that you need to register for this workshop, and we have kept a very minimal amount of 200 rupees. Also, in the bottom of this page, you will find certain agenda for this workshop, so you will get a whole idea like what all we are going to discuss. This is just a prima facie, things which we have discussed on this site, but we have a lot more in the workshop. So I believe that everybody is excited. Also, the faculty would be a very experienced faculty, though Mr. 𝘠𝘃𝘠𝘬, he himself has cleared judiciary examination. So getting a advice or a workshop from that person who himself has cleared, it's a big thing. So if anybody is interested, I'm just sharing the link with you all. Also, I'm sharing a link of our chat WhatsApp group, where you will find certain other updates regarding 𝘓𝘂 and regarding the workshop. Okay, I believe that is it. And Arpana, we can continue with our
Yeah.
live mock.
So we were on question number 13. It says that quid pro quo means something in return, accuracy of considerations, sufficiency of consideration, and value of promise.
And your time starts. Okay, I guess this question was there already on the screen. So I'll just provide you 5 more seconds to it, because yes, time's up.
Yeah. 1 second, I guess. Now it's working. Yeah. So the correct option over here is option number 1, that is something in return. So it is a Latin term, and it means that something for something. And it is used in English to use. It means an exchange of a good or services in which one transfers any contingent upon the other. So this means quid pro quo. Now, question number 14. Question number 14 says quasi-contract are the situation where law creates obligation for a non-contracting party, law create obligation for breach of contract, law create obligation for the contingent contract, law create obligation for mistake of facts.
And your time starts. Okay, 10 more seconds to go. Try to answer. And time's up.
Thank you, Anu. So the quasi-contract is that when there is no agreement between the two parties, and one party, they do something for the person, and because of that, there is a specific, the duty towards another person, then it is called quasi-contract. For example, if a person has given a minor some money for his education or something, so after he graduates, he has this obligation to return it back. Now we have question number 15, that is A sales by auction to be a horse which A knows to be unsound. Which one of the following situations amount to fraud? A remains silent and say nothing to be about the horse unsoundness. B is A's daughter and has just come of age, and A remains silent and says nothing of B about the horse's unsoundness. A says to B, If you do not deny it, I shall assume that the horse is sound. A says to B, the contract is an as it is contract. You may bring in your expert to examine the horse. A has private information of a chance in price of horses in the market, which, if told to B, would affect A's willingness to proceed with the contract, and A remains silent. And your voice is breaking.
Am I audible now?
Yes.
Right. Okay, participants, we have 10 more seconds. Try to answer. And time's up. Please stop answering.
So the correct option over here is option number 2. Now, let us move to question number 16, which is, which of the following does not vitiate free consent under the provisions of Contract Act? Mistake of law in force in India, misrepresentation by mistake, mistake of fact by parties to the contract, and undue influence.
Yes. The time has already started. We are on question number 16. Few more seconds to go. And time's up.
Yeah. Thank you, Anu. So the correct option over is option number 1, that is mistake of law in force in India. This is, this does not vitiate any free consent under the provisions of Indian Contract Act. Now, Headley versus Baxendale deals with remoteness of damages, breach of an implied terms, payment of a penalty situated in the contract, anticipatory breach of contract.
Participants, your time has already started. And more seconds to go. And time's up.
The correct option is option number 1, that is remoteness of damages. So Headley versus Baxendale, it was a leading case for the remoteness of damages, where a mill owner gives his machine to the transferer to get it repaired, and because of delay, he faced losses, and he filed a case against the person who was transferring his machine to the repairing company. So here that company has not seen that because of his delay he is facing losses, and so the cases. Now, question number 18. Who is called a promisee according to Indian Contract Act? The person to whom a proposal is made, a person accepting the proposal, or a person furnishing the consideration of the promise, a person to whom a promise is made.
Okay, time has already started, participants. 15 more seconds to go. And time's up.
Thank you, Anu. The correct option is option number 2, that a person accepting the proposal is called promisee, and the person who gives, gives the offer is, sorry, the person who gives the proposal is called proposer. Now, question number 19, a waging agreement is voidable and enforceable, void and not enforceable, valid, valid but not enforceable.
45 seconds has already been started, participants. Fifteen more seconds to go. And time's up.
Thank you, Anu. Sorry. I'm so sorry. I just went to the last screen. Yes, we were on this question. So the correct option is option number 2, that is void and not enforceable. Under Indian law, waging contract agreements are void and they are not enforceable by law also. They are void. Now, question number 20. What among the following is known for change of the nature of obligation in the contract, novation, recession, revocation, or alteration?
The time has already been started. Ten more seconds. And time's up.
So the correct option is novation. That is, novation is known as a change of the nature of the obligation in the contract. Question number 21. Which of the following statement is correct? Stranger to consideration will be a stranger to contract. Stranger to consideration has no right. Stranger to contract can enforce promise. Stranger to consideration can enforce a promise.
The time starts, participants. We have 15 more seconds. And time's up.
So the correct option is option number 4, that is stranger to contract and enforce a promise, as we have seen in the case of Chenaya versus Amelia, the aunt and the niece case, where aunt was not part of the contract, but she has the right to enforce the contract between them, because she was a stranger to consideration, but she was getting affected by the contract. Now, question number 22. If the compensation to be paid on the breach of the contract is the genuine pre-estimate of the prospective damages, it is known as special damages, penalty, unliquidated damages, or liquidated damages.
Has already started, participants. Fifteen more seconds. Question number 22. Five more seconds. And time's up.
Thank you, Anu. The correct option is liquidated damages. And what is liquidated damages? It is the amount fixed by all the parties in a genuine estimate of the loss by the future breach of contract. Then it is liquidated damages. Thus, all the parties to the contract agrees to the amount is fair compensation for the breach of that contract. Now, let us move to question number 23, that is reciprocal promises provide for doing certain things which are legal and certain other things which are illegal under section 57. The first set is valid, but the second set is void. Sorry, this is the first set. I'm sorry for the spelling mistake. The first set is voidable, but the second set is void. The entire set of promises is void. The entire set of promises is valid.
Time has started, participants. Ten more seconds to go. Try to answer. Question number 23. And time's up.
Yeah. Thank you, Manu. So the correct option is option number 1, that the first set is valid, but the second set is void. Now, let us move to question number 24. That is, a contract not specifying the place of performance can be performed by any place to the knowledge of promisee. The promisor need not seek any instruction from the promisee as to the place of performance. The promisor has to apply the promisee for appointment of a place of performance and perform the promise at that place. The promiser can perform the promise at a place other than the place of, appointed by the promise.
Your time starts now. We have few more questions, participants. And also we have few more seconds. Try to answer. 6, 5, 4, 3, 2, 1. And time's up.
Yeah, thank you, Anu. So the correct option over here is option number 3. That is that where in a contract no specific place of performance is mentioned, then the promisor has to apply to the promisee for appointment of a place of performance and perform the promise at that place. Now, Question number 25. What is a reasonable time for performance of a contract? It is a question of law. It is a question of fact. It is a question of prudence. It is a mixed question of fact and law.
That has already started, participants. Am I audible to everybody?
Yes, you are.
Okay, time's up. Actually, my internet connection got stuck. So time's up.
Okay, okay. So the correct option for this is that it is a question of fact. So wherever there is no reasonable, wherever there is time not mentioned in a contract, then reasonable time is given to a person, and that reasonable time is according to the facts of the case, or whatever the situation is that there. So if the there is a contract to make a heavy machinery, then then the time will be big. And if there is a contract for making a small for example a paint a small thing or some for by an origami, so the time will be less. So it will always depend on the time
Okay,
circumstance.
yes, I received only one answer for question number 25. I guess my internet got stuck, so I didn't receive much answers. I received only one question. Can we cancel this question? Because I don't have answers, and I believe that many of our participants had answered for this question. So I'm so sorry, participants. I just received one answer, so I guess cancellation of this question would be appropriate.
Yeah,
Yes.
okay, no problem. Now let's come to next question, that is
Okay.
question number 26. If the time of performance of the contract is the essence of the contract, and the promisor fails to perform the contract by the specified time, the contract becomes void and is unenforceable. The contract remains valid and is unenforceable. The contract became voidable at the instance of the promisee, and the contract, though valid, become unenforceable.
The time is running, participants. We have 10 more seconds. And time's up.
Thank you, Manu. So the correct option over here is option number 3, that the whenever time time for performance of the contract is the essence of the contract, and the promisor fails to perform at that time of the specific time, then the contract become voidable at the instance of the promisor. Now, question number 7, that is, in determining the questions of inadequacy of consideration is referred uh, option over here is undue influence, fraud, misrepresentation, or free consent.
And time starts. This is the third last question of the day. Try to answer, participants. Am I audible to you?
Yes, Anu.
Okay, time's up.
Yeah. The correct option is option number 4, that is pre-consent. Now let us come to question number 28. A sails by auction to B a horse which A knows to be unsound, which one of the following circumstances amount to fraud. I guess this the question sorry, the option over here is A remains silent and say nothing to B about the horse unsoundness. B is A's daughter and has just came of age, and A remains silent and says nothing to B about the horse's unsoundness. B says to A, if you know, do not deny, I shall assume that the horse is unsound. A says to B, this consent, the contract is as is contract. You may bring in your expert and examine the horse. A has private information of a change in the price of the horse in the market, which if told to B would affect A's willingness to proceed with the contract in sell.
And your time starts now. We have few more seconds. And time's up.
Yes, the correct option is option number 2. Now let us come to the second last question, that is a promise made without any intention of performing it amount to caution, undue influence, fraud, none of the above.
And your time starts now. Okay, participants. Am I audible to everybody?
Yes, Anu, you are audible.
Okay. So time's up.
Okay. So the correct option over here is option number 3. Now this is the last question. Consideration for the contract specified equality in contract, fairness of contract terms, valuation of contract, or bargain elements in a contract.
Participants, the time is running.
So this is the last question for our course.
Ten more seconds to go. And time's up.
correct option is option number 4, with a bargain element for the contract. So the consideration is a bargain element between the parties of a contract. So this was all about our quiz. Thank you everyone to participate so enthusiastically. I'll just stop sharing my screen.
Yes. Okay, I'll just get back with our results today. And I appreciate that many of our participants participated today. And if anybody is having any query, so they can ask regarding the today's webinar, and also regarding the workshop. If they want any other link, I can provide to each and every one. So you can either ask in chat box or in Q&A. And I'll just get back with our top three winners.
Yeah. Thank you, Manu. So let me tell you about our workshop. Um, so in our workshop, you will get all the insights of how to crack judiciary. And you know why this workshop is very important, because this workshop is going to tell you about what books you have to refer, how to prepare, what are the general mistakes which judiciary aspirants make, and how to rectify your own mistakes. And then lastly, how to deal with multiple state uh, judiciary at once. As the key speaker, we have Mr. 𝘠𝘀𝘆, who has already cleared many state judiciaries, and he is cleared 𝘂𝘅 two times. So he is an expert. And we have Mrs. 𝘍𝘍𝑇𝘍𝑒𝘆, and she is, you know, she has a good experience in preparing judiciary aspirants. So this is a very good opportunities for you all to go cope up with the if you have this dream that you want to go for judiciary, then it is very good. So we have one person, Dr. Ashok Kumar. He said, I joined 10 minutes late because of internet problem and did not know how to answer the question, whether in chat box or thinking, so I could not attend. Okay. So thank you. It was a good, you appreciated our session. So how to answer is that for the next time, Mr. Ashok, you have to write question number and the correct option in the chat box itself to answer this question. So to answer the question simply. So we have another. Will the workshop be helpful for AIB candidates? See, the workshop is basically for the judiciary, but yes, it the course is similar, so it is definitely going to help other aspirants of who are willing, who are giving other competitive examinations. They will be uh, definitely helpful for those also. So if you are giving AIB, you can definitely attend the workshop because the course is similar. So it will definitely going to, you will definitely get some fruits out of it. Thank you, Samaina. If anyone have any other question about the workshop or any query about any of the competitive exam, how to prepare and anything, I'll just answer your question. Thank you, Ina. So I guess there are no other questions. So let me talk. That we have only minimum amount of 200 rupees for the workshop, and this workshop is on December 14th. So I would highly recommend to all the judiciary aspirants to join the workshop, and other students who are going to give other competitive exams relating to law. Please definitely attend the workshop. It will definitely going to help you. It will going to give you how to prepare for these all kind of examinations. Dr. Ashok has asked, I would appreciate if in future sessions it will be made clear whether it will be question answer session or session addressed to that. Yeah, it is a question answer session. Any other question? You can just ask me for the workshop. Veena, okay, sorry, Veena, I have not seen your message. Yours, I just entered into law. Is there any problem in attending the? No, no, no. It is not any. There is no problem attending the live webinars. You can definitely, as much as you will connect to the, profession, it will definitely going to help you. So please, you can go to the webinars. Now, another question, will they cover answer writing? Is they will cover all the answer writing, judgment, drafting, everything in the webinar, everything related to judiciary. Thank you, Veena.
Okay, so let me just take a minute and let me just announce first winners for today's session. And indeed, of course, questions was very good, and many of the participants participated today. So, without any delay, let me just declare our today's winners. And it is I've taken winners from both YouTube and our Zoom live channel, right? So I've taken the four positions. At a fourth position today, we have Mr. Jagannath and our YouTube viewer Ankita Kar. So congratulations, both of you. On the third position today, we have Ms. Neha Gandhi. So congratulations, Neha. On second position, we have with us Alekhya P. So congratulations, Alekhya. And first position today secured by um, Sumheda Kalsi. So congratulations are today's winners. And this was from my side. And of course, I'll request each one of you to kindly provide your feedback with us on the scale of 1 to 10. So it will help us to improve our content quality. 1 being the lowest and 10 being the highest. Okay. And Arpana, yeah, if you wanted to say something.
Yeah, thank you, participants, and thank you for everyone who is participating. And congratulations to the winners. Uh, Keep quizzing, and we will come up with more live quizzes from different topics of law.
Right. I hope, yeah, nobody has any doubt regarding any questions, and Arvina has already cleared all the doubts regarding the question which we had. And okay, yes, we will coming up with some other live mocks as well. So keep quizzing everyone, and now I'll sign off. Webinar executive Anu Bhatnagar, and thank you so much for providing such a wonderful feedback to us. Thank you, everyone.
Thank you.